Hello and welcome everyone. I'm glad to welcome you to this event launching the book by Antonio Cocco, The Defense of Mistake of Law in International Criminal Law. I have a copy of the book here that I hope can be shown. And my name is Paola Gaeta. I'm professor of international law at the Graduate Institute in Geneva. And I'm very pleased to chair this book launch organized by the American Society of International Law. And we have a wonderful panel to discuss the book by Antonio Cocco. First of all, we have the author himself of the book, Antonio Cocco. And then we have three distinguished panelists who will be discussing with us the book of Antonio and bring about a further reflection on the relevance of the defense of mistake of law in the case of international criminal law and international crimes. So let me introduce quickly, first of all, our panelists. We have Kate Gibson, who is defense counsel and a president of the Defense Counsel Association, and she has been defending accused before international criminal courts and tribunals since a few years now. And welcome, Kate, to this panel. And then we have the pleasure also to represent the prosecution today. So we have the defense lawyer, but also the prosecution, because we have the pleasure to have Matthew Cross. Matthew Cross is working at the International Criminal Court since many years, and being what's your position as a counsel for the prosecution? How is it?
Perfect.
And Matthew, of course, today speaks in his private capacity. He's not representing at all the International Criminal Court. And also, Matthew is serving as a member of the editorial committee of the Journal of International Criminal Justice, among other things. And then we have also the pleasure to have Umar Ba. He's a professor of international relations at Cornell University, who has been the recipient of a variety of prizes for his books and articles, and with a focus on a variety of issues, including international criminal justice. So, Umar, welcome. I'm happy to be here. But I think that first we have to start with the author of the book that today we celebrate. Antonio, do you want to say a few words about yourself and the book?
Well, first of all, thank you, Paola. I am honored to be here in this panel of distinguished speakers chaired by you. I should disclose that Paola Gaeta was the supervisor for my PhD, which constitutes the backbone of this book. Of course, I worked on it after the PhD, but the foundations reside in my studies in Geneva, the University of Geneva. I should say that the book actually originates in my experience prior to becoming an international lawyer, because before studying international law at a PhD level, I practiced for a little bit domestic criminal law in Italy, and I was in fact a defense counsel for a while. And these generated in me curiosity about the practical working of the rules on defenses before domestic courts, but therefore when I acquired an interest in international criminal law, this interest was transposed towards the defenses for charges that can be brought before international criminal tribunals. And in particular, when I was discussing with advisors, including Paola, a topic for a possible PhD, I thought that the defense of mistake of law is one of those that are usually least considered and least studied, perhaps because it is used so rarely in practice, and because it is perceived that it can never succeed, particularly for crimes as serious as those adjudicated by international tribunals. There is always this maxim that ignorance of the law is no excuse, and we repeat it as if it is a religious rule almost, especially in the case of war crimes, crimes against humanity, genocide, or the crime of aggression. However, I was curious because I realized that the rules are not so clear-cut. Already at the domestic level, there are numerous exceptions in which ignorance of the law actually does excuse. And I embarked into a PhD journey, a research journey over 10 years ago that lasted numerous years. And I hope to have provided some helpful research for practitioners and scholars. And I look forward to discussing this with you, with the panelists today.
Antonio, we will discover to what extent your book is of any practical relevance to defense lawyers and practitioners more generally. But it's true that the topic of defenses in international criminal law is something that is quite always difficult to be discussed, because in general we are not open to the possibility that persons accused of international crimes, so serious for international criminal as a whole, to repeat another mantra, may be excused or may be relieved of their criminal responsibility for the operation of certain defenses. And mistake of law is one of the most difficult of those defenses, as you correctly pointed out. So I'm very happy to have the possibility, we're very lucky to have the possibility to discuss about these issues with, first of all, Kate Gibson, because since she's a defense lawyer, she can tell us more about the tricky issues that the defenses in general are raising for international criminal trials concerning international crimes, but in particular for the defense of mistake of law. So, Kate, can you share your thoughts with us on those issues?
Yes, thank you very much, Paola. Good afternoon, good evening to everyone joining online, my fellow panelists. Antonio, I'm so glad that you wrote this book, and I'm so happy that I've now read it, because this whole area of positive defenses is sort of this real black hole for practitioners, in terms of the fact that the law is very complicated, and it's in some ways counterintuitive and a bit uncomfortable, I think, because sort of the starting point is that the backdrop of our practice are some of the most horrific events of our common history. You know, we're talking about genocide, we're talking about crimes against humanity. Are you really going to stand up and say, well, my client shouldn't be found liable because he didn't know what he was doing was illegal, right? These are crimes of horrific scale and gravity. We're not talking about zoning regulations that didn't get published or something. Why are we even talking about defendants making mistakes of law? Why does this have any place in our field? And of course it does, for the reasons that you explain very well in your book. But I really see this as one of the fundamental challenges to invoking mistake of law, that there's this aversion to defendants trying to sort of excuse themselves in this way. There's this presumption, I think, that raising mistake of law is some kind of ex post rationalization of a conduct that defendants knew very well was criminal. So that's one challenge I see. Secondly, and obviously I'm going to exclude from this comment anyone I've ever represented or are currently representing, but generally, invoking mistakes isn't often compatible with the personalities or characteristics of typical defendants, right? The charging policies of international criminal courts and the modes of responsibility that are employed means that ICL is geared towards larger fish rather than smaller fish, right? So defendants who are former heads of state, heads of government, generals from armies, leaders of militia groups, who will typically defend accusations against them on the basis of, you know, I wasn't the commander of those troops. I did take effective measures to prevent and punish. I wasn't part of a common criminal enterprise, rather than I made a mistake. I'm an ignorant person. I'm an unsophisticated person. I didn't know what I was doing was wrong. I think it's very rare to get instructions from these types of defendants to proceed along those lines. So I think that's another challenge, a practical challenge to the regular invocation of this defense. But I think, you know, the biggest challenge is that the state of the law isn't really very helpful to the defense. Mistakes of law don't provide a valid excuse to crimes, and we see clearly from your book that scope for fashioning an effective defense is really limited to where the mistake would negate the mental element of the crime involved. So I'm just going to end by saying what I really appreciate about your book is you start from the point that this defense does exist, and it must exist because people can't be held criminally responsible for crimes when they're not blameworthy for their conduct, right? Without this sort of strict adherence to this idea that individual criminal responsibility has to stem from culpable conduct and not mistaken conduct, then we're not going to have fair trials. And your approach, you know, it makes perfect sense that you're a former defense counsel, because you don't sort of fetishize convictions, but you really hinge all your analysis around fairness and legitimacy. And you're very open that your starting point is that, you know, incarceration, punishment is a really severe restriction on an individual's fundamental rights, so it has to be properly justified.
Can I interrupt you? Because
yes.
What you say is perfectly makes sense, of course. So the practical challenges, you know, in raising as a defense lawyer the defense of mistake of law, and in general defenses, but in particular the defense of mistake of law, and you pointed out, of course, also the factor that usually the person charged have a big fish, as you said. But in this respect, may I ask you something? Two things, perhaps. The first thing that is not always we have, including before the ICC, the International Criminal Court, big fish who are charged. So this is a tendency, but it's not necessarily true, because we have also small fish before the ICC. And this, perhaps I would like to ask you to what extent, in this case, a less sophisticated person might have, on the contrary, some interest in raising the defense of mistake of law. Because of the difficulty of understanding sometimes the law that is applicable to them. And in this respect also, may I ask, I mean, the law that we mean to apply before the ICC and the International Criminal Court of Tribunals may sometimes be unclear, even to the judges. And indeed, we have a variety of dissenting opinion pointing out, you know, that there is disagreement among the judges themselves about the content of the law, the interpretation of the law to be given. So to what extent this has an effect, has an impact on the possibility for the defendant, you know, to rely upon the defense of mistake of law.
I mean, those are two excellent questions. In an ideal world, international criminal law is this perfect, complete, coherent, universal thing. But it's not. We can see that it's volatile and fragmented, and I in no way would claim to have perfect knowledge of all the Article 8, of all the war crimes, of all the crimes against humanity, and what all the elements are. But at a fundamental level, the argument to counter that is that there is a universality to the moral conduct that we're talking about. And so we have to be able to accept that people understand, even if they don't have this perfect knowledge of the bounds of international criminal law and where it lies, they are understanding that what they're doing is in some way a breach of our sort of common universal moral code. I think that's how prosecutors would see it, but I'm going to leave that to Matthew. In terms of the big fish and the small fish, I mean, it's very interesting because we can see from the examples where mistake of law have been invoked that it has been invoked along those lines. In terms of smaller fish, you know, one of the cases where a defendant invoked mistake of law was Florence Hartmann, who was the former spokesperson, right, of the ICTY, who was charged with contempt. So we're not talking about, you know, a leader of an army. We're talking about a person who said, was having been charged with publishing confidential material. She said, I didn't know that this was confidential. I didn't know what I was doing was wrong. So I think there is a bigger scope when you're not talking about people of the stature of the typical defendants. And we can also see that when, for example, mistake of law was invoked at the Special Court for Sierra Leone, where defence counsel raised mistake in relation to accused and said this particular accused didn't know it was a crime to recruit and use child soldiers, okay, because his government was doing it, everyone else was doing it. You know, there are different conceptions of age within African society, and they did play on this concept of his lack of sophistication. He's not someone who's walking around with international conventions in his back pocket. He's being governed by the culture in which he lives. So I think your point is a good one, and we certainly see that the door is there for the smaller fish, so to speak.
Thank you very much. We will come back to this issue of the universality of the values protected by international criminal law in general, and the problem of cultures, as you mentioned now. Perhaps we will come back to this issue later on. But thank you, Kate. I would like now to give the floor to the prosecution side. No, it's not to the prosecution, Matthew. I'm joking, of course. I know you're speaking in your personal capacity today. So Matthew, but I mean, I don't know, first of all, I would like to know if you have any reply to Kate's points, first of all.
Thank you very much, Paola, and to Kate as well. And I've found that it's always a good idea to agree with Kate, even when I don't agree with her. But actually on this occasion, I basically agree with everything that she said. I think one of the big challenges for the defense, I think for everybody, is, I have to say, of all the possible defenses and all the areas of the Rome Statute, conceptually it asks some of the most difficult questions. And I think getting to grips with what it really means in terms of a practical application at the court is probably going to remain open until we get the cases which come before the court where we can actually apply it to some concrete facts. Because fundamentally it is about fairness, and it is about working out what is a fair conclusion in each case. And in the abstract, that's very difficult until we have a factual framework in which we can start to work it out step by step and case by case. I also think Kate's right that it's probably not going to be a factor which necessarily comes up very often, because of course the mistake of law provisions in the Rome Statute don't exist in isolation. The Rome Statute has other mechanisms which also, in kind of less direct ways, but are trying to ensure that the Rome Statute and the ICC are always dealing with cases where the culpability, assuming that the facts in dispute are proven, and of course it's the job of the prosecution and the defense to argue about those facts. But if the facts are true, then in theory the cases which come before the ICC should be those cases where the culpability is pretty obvious. We have the sufficient gravity requirement in Article 17(1)(d) of the statute, and of course the prosecutor of the ICC has considerable discretion in terms of the cases which will be brought before the court, because the court can only ever prosecute a fraction of the cases which are likely to arise from any situation. So if you put all those things together, absolutely there must be a place for mistake of law in our discussion, because it is an essential aspect of fairness, and that fairness is a part of legitimacy of the ICL institution. But at the same time, how long we'll have to wait and in what circumstances until we start to tease out, well, how will this defense apply in practice and what does it mean? That's going to be a long project, which of course is one of the reasons why it's so fantastic to have Antonio's book and to have opportunities such as this to start to think about it and really to test what we might expect and where we find that we're probably in more agreement maybe than we might think we are. So yeah, absolutely, I agree with what Kate said.
Thank you, Matthew. Back to the fact that, I mean, the defense of mistake of law does not exist in isolation within the Rome Statute. You're perfectly right. I mean, there is a system within the Rome Statute is a system. It creates a system, as we know very well. But I mean, to what extent, I mean, in a way, we can go back a bit to the idea of the universality of the values protected by international criminal law that Kate was mentioning in light of the Rome Statute and the universality of the values embedded in the Rome Statute, and the fact that the Rome Statute is not universally accepted as a treaty. So how the defense of mistake of law comes into the picture here? I mean, you say, of course, one has to ensure fairness and so on and so forth. What about the complex relationship between universality, universalism, and universal ratification of the Rome Statute and the defense of mistake?
Thank you. Well, again, it's a huge question, and the framing in Antonio's book helps us to understand why. Well, it hints at why, but at least it sets out the parameters of the discussion about how you frame mistake of law in the context of an institution such as the ICC. as a massive oversimplification of Antonio's scholarship. On the one hand, you could have mistake of law as a failure of mens rea, which is the approach that we have in the Rome Statute. On the other hand, you could have mistake of law as a much more general excuse based on your ignorance of the law. So the question for us is, well, the draft of the Rome Statute have chosen to calibrate Article 32.2 in a certain way. And we might ask, well, is that the right way? Is that the appropriate way given the functioning of the court? My instinctive answer would be to say, well, yes, it is. And to some extent, maybe that would be Kate's view as well, because it does come back to the function of the court, and it does come back to the universality of the crimes that we have. In the conclusion to Antonio's chapter, he has a lovely phrase where he says, well, the challenge for the court is ensuring that it sufficiently places the humanity of the defendant alongside the humanity of the victims. And I think that's both a lovely way of putting it, and I think maybe Antonio's choice of words is a very careful and balanced choice. Because of course, when we talk about the humanity of the defendant, of course that means recognizing that humans are fallible and can make mistakes and can fail to understand things. But also in that notion of humanity, we have the sense of essential values, essential standards, things which might be universal. And we see that in provisions such as the superior orders provision in Article 33.2, where it says, well, it's not within the scope of superior orders if the order is manifestly unlawful, and it says that crimes against humanity and genocide are per se manifestly unlawful. So already, in the statute, very explicitly, it suggests that there are certain crimes which it's presumed, by virtue of our humanity, we will understand that those things are wrong in themselves. And the book describes in great detail how with the other crimes and other elements, there are certain bits where mistake of law may be apposite and certain bits where it won't. So that leaves us with the question, if it's the case that by and large, a lot of the crimes in the statute are themselves crimes for which we think it's appropriate to see a certain scope of the rule of law, does that then mean that we are accepting a certain way in which the ICC is going to operate both now and in the future? For example, at the moment we have the classic international crimes under the jurisdiction of the ICC. We have crimes against humanity, we have genocide, we have war crimes. And to different degrees and in different ways, and it's probably more conversation than we've got time for today, we can say, well, maybe all of those categories of crimes, most of the time, will be regarded as wrong in themselves. But what happens if we start to think about other types of crimes? What happens if we think about ecocide? Obviously, there's a lot of contemporary discussion about that. What happens if we think about corruption? There's quite a lot of discussion about that. These crimes, there's surely an argument which says, well, they also touch on a fundamental or essential moral wrong. And so maybe some of the same kinds of arguments might be mounted. But I think there's probably also a stronger case to say, well, those crimes are more regulatory in nature. And if you put those into the Rome Statute, then do we need to think about actually what's going to be the scope of mistake of law? And is the scope of mistake of law, as we've got it calibrated for, if you like, the traditional Article 5 crimes, is that necessarily going to be the same for new kinds of crime, even if we think that they are worthy of international attention and potentially prosecution? So one of the great strengths of the book is that it tries to wrap up both the project of what we're doing in international criminal law with this concrete criminal law concept of mistake of law and of fairness, and trying to bring those two things together.
Thank you, Matthew. It is fascinating, and I think that I will take from you to go to Omar, because you say, in a way, you seem to assume that well, whatever the crimes that are enshrined in the Rome Statute reflect, in a way or another, some moral wrongfulness, no? Then, well, perhaps the question of fairness would be respected if the mistake of law is excluded to some defendants accused of those crimes. Which again brings us to the question, first of all, is moral wrong necessarily equal to criminalization? And then is what we consider to be moral wrong in the Rome Statute necessarily universally, no? be extended. So I would like to ask Umar, what do you think of this debate on the universalism or universality of the values protected by the crimes enshrined in the Rome Statute? Because in a way, I mean, the defense of mistake of law is closely linked, the inevitability of the defense of mistake of law in principle is closely related, to the universalism also of those values. What's your view on those matters?
Thank you, Professor Gaeta, and I have.
I called you Umar, and I hope to be called Paula.
Yes, thank you, Paula. This is a great question, and I did enjoy the interventions from both Kate and Matthew. Let me also say that I am the non-lawyer on this panel. I do not have a legal training. So I'm trained as a political scientist. I study international relations, and I focus specifically on the history and the politics of international law. So I'll be coming from this angle. So that's my disclaimer.
This angle, I must say, is often the most difficult one, exactly, because you get the questions or the points you never thought of, as a lawyer. So
Yes.
Thank you for your contribution.
And also reading this book was, for me, really eye-opening. This was a great learning exercise for me, and I've learned so much from the book. And to answer the question about moral grounds and the universality of international law, let me first raise the issue about the knowability of international law itself, because if you're speaking of the mistake of law, it does assume that one must already know that law, and whether international law itself is knowable. And Antonio does raise this question in the book as well, because it's so complex and complicated and technical that assuming that one knows the law in itself is too much a leap of faith. And at the same time, do all have equal access to the knowability of the law? The other question beyond the knowability of the law itself is that in the case of the ICC, as both Kate and Matthew has talked about, we're dealing with the most serious crimes that exist, or at least that are defined as such. And because of that, one would find it hard to convincingly argue that they did not know what they were committing. Those acts would qualify as a crime, because apparently there is some universal moral codes that one should be aware of, and breaches of those codes would amount to violations or to hurting humanity, therefore warranting a punishment. But then the other issue is whether there are actually universal moral codes, and whose moral codes are there. Because we do know that international law doesn't come out of a vacuum. We do know that there's a very specific history of international lawmaking, and a lot of scholars have made the argument convincingly, I think, that international law is actually a legacy of the colonial encounter, that it does have a specific history of the Western world encountering the other and modifying and creating a number of rules and systems, and we are still operating within that legacy for all the way from what is defined as a crime, what is the kind of punishment that is meted out for breaches of those codes, what are the temporal limits that are placed within the definition of those crimes. So all this puts back the question whether international law is universal. Is it an aspiration? Does it come from a specific place? Does it govern specific kinds of relations among different kinds of societies? And if we are dealing with such a question, let me just mention maybe briefly one specific case, Dominic Ongwen case, for instance. When I was doing my dissertation field work, I went to northern Uganda, spoke to people in Gulu, and some of them, what they told me basically was that in their culture, there's no crime that cannot be forgiven. And as such, they would have wished that actually when Ongwen was captured, that he be brought back to northern Uganda, go through some forms of rituals and cleansing rituals that are very important to them. And then after that, they'll see what is the route to deal with this. But again, because I don't know whether Ongwen did invoke the mistake of law. I don't think he did. But assuming that, a minor, someone who is a child, can argue mistake of law. So I'm speaking in hypothetical here. So, but then he was an adult accused of having committed crimes as an adult. But there is also the argument that his childhood experience, the trauma he went through, did play a role in the acts that he may have committed later as an adult. But then the court would, dismiss that aspect of his experience as a child who went through some experiences that may or may not, it's up to the experts to determine that his acts later on. So even though he may not have invoked the mistake of law, that should definitely have been part of the judgment. That should have been part of the question of what kind of punishment is fair in these instances. So that gets back to the idea of what kind of punishment is meted out for specific cases such as that one, or cases that are tied to specific cultural understandings that the court is not equipped to deal with or unwilling to actually deal with. And I'll stop there for now.
Thank you, Maro. May I be in a way provocative now? Because certainly you raise a very important point of the criticism which is raised often of the colonial descent, you said of the international criminal law, and I wanted to challenge you on that. Is it international criminal law in relation to the crimes it tries to make people accountable for? Or is it the project of international criminal justice? Because I think it's not necessarily the same stuff. Because indeed, you mentioned Ongwen, and you said that in his own community, what he did was considered to be crimes, but the difference was that in that community, perhaps the approach vis-a-vis those crimes was not to bring the person accused to trial, but perhaps to go through different kind of procedure to forgive them. But the assumption was nonetheless that what he did was wrong. But the way to deal with these crimes is different depending on the society. So is it the criticism about international criminal law in the crimes that are not universal, or is not more about the project of necessarily responding to these crimes with the Western conception of the trial? The first thing that I wanted to ask you. And secondly, you mentioned in the case of Ongwen trial again the problem of the impact that he had as an experience as a child soldier in his criminality. And indeed, perhaps this is the follow-up question about the problem of the legitimacy of international criminal trials, but we can go to that in one sec. What about the first issue?
Yes, thank you. That's a very good point to make, to distinguish international criminal law from international criminal justice. And yes, I totally agree that these acts would, even in that cultural context, amount to either crimes or breaches of the moral code, and the difference may be about what kind of how to deal with them. But it is not just that international criminal justice that is a legacy of the colonial encounter or of othering, for coming out of a specific Western standpoint. Even the crimes themselves, the core crimes that are defined as in the material jurisdiction of the Rome Statute, coming all the way as a legacy of a Nuremberg. There was very specific moments at the ILC, for instance, during the drafting of the code against the Code of Crimes against Mankind and Justice. The African countries, for instance, came up with specific proposals about what should be codified as international crimes. And Matthew has talked a bit earlier about ecocide, which is now being debated, and there's an attempt to codify it. But in the 70s and 80s, African countries proposed at the ILC that the willful destruction of environment and the dumping of hazardous waste to be codified as international crimes. They also proposed colonialism to be codified as international crimes, and Western states opposed all that and then just retained those four core crimes that ended up being part of the Rome Statute. So there's a long history of attempts from other peoples to codify what they viewed as a very serious breaches of international law, but it did not fit necessarily the interests of the most powerful states, and therefore that has not been codified.
Thank you very much. I see the point. It's the perspective of what qualifies as an international crime, as a crime of international concern. I totally understand your point. But I mean, something in the book of Antonio, the last chapter in particular, speaks about the relationship, and also Matthew has mentioned it, the relationship between the defense of mistake of law and broader the project of international criminal law, international criminal justice. Do you have a particular view on these considerations by Antonio concerning the legitimacy aspect of the project of international criminal justice, to whom for whom the punishment is administered? I mean, do you have any particular view on that?
Yes, I think Antonio raises a very good point about who is the audience of the international criminal justice regime of the ICC. The purpose of punishment, or the proceedings themselves. Are they speaking to the defendant? Are they speaking to other states? Are they speaking to the international community, or are they speaking to the victims? And there are multiple audiences here, of course, which makes it a bit of a challenge to balance what kind of message is being sent here. And I think Antonio does a great job at speaking to the various contingencies here. Ultimately, though, that may also work not in favor of the defendant themselves, because if the audience becomes would-be perpetrators in the future, then maybe the punishment could be harsher than if it was just about what is this person guilty of and what is the appropriate punishment, because the court may be speaking to a wider audience and therefore taking decisions that are not necessarily the warranted one for that specific person and that specific act in that place.
Thank you very much, Omar. It's wonderful. So I think that now, since we have 20 minutes left, first of all, I would like to invite people listening to us to ask questions. I see already that there is one from the audience that let me check before giving the floor to Antonio for a rejoinder. That's an important question. So Kathleen is asking, can culture be shielded from criminal culpability when the culture has been constructed and maintained by patriarchal power structures? especially in the case of crimes against women and girls who have not had an equal say or an equal voice in this system and are discriminated against. So she mentions Kathleen and marital rape, for example, in local societies, will thus excuse rapes, enforce marriages in armed conflict, and so on and so forth. And she also mentions the example of Taliban who rely on their religious and cultural views vis-a-vis women who defend their oppression. So who would like to take this question? May I give it to Kate, perhaps?
Obviously, simple answer, no. Culture shouldn't be able to act as a shield to criminal culpability. And I think the way that mistake of law is framed, particularly at the ICC, the question is whether or not the accused in question had his ignorance of a particular part of the law negated an element of his mens rea. But your question is extremely interesting because we see sort of overtures of this in some of the cases at the ICC. One that comes to mind is the Al Hassan case, which is currently in the deliberations period at the ICC. Mr. Al Hassan is accused of being, the de facto chief of the Islamic police in Mali. And so the issues that you're raising are issues in the case. He's accused of other things, among other things, of having criminal culpability for the sanctions that were being handed down by the Islamic police and the Islamic tribunals in 2012 and 2013. And in terms of how this plays into mistake of fact, we can see that the defense team of Mr. Al Hassan argued specifically that he wasn't aware that the sanctions that were being handed down within that framework in Mali wouldn't constitute lawful sanctions. So that's where mistake of law kicks in. But there's no suggestion either from the defense, and I'm sure we'll see in the ultimate judgment, that cultural misunderstanding then comes in and acts as a shield for, in particular, crimes against women, because of the way that the society is set up. That shield would only be in place if an element of the crime is negated by him not having the relevant mens rea. So I think it's a really important question, but I think the answer is still that no, that there isn't that opening there for the shield for crimes, even when the society is sort of set up in that way.
Let me see if Umar would like to see things differently, perhaps. What do you think, Umar?
I agree with Kate, and I just also want to clarify in my discussion earlier, I was not engaging in cultural relativism. I was not trying to invoke cultural practice.
Clarify, indeed.
Yeah, so that I want to make it very clear. I was not arguing that some cultural practices should not be punished because they are cultural, not at all. It's just was an attempt to point out that international criminal law itself comes from a very specific place, has a very specific trajectory, and we need to discuss and understanding as such.
Thank you. Anyone who would like to say something on the matter, Matthew?
Yeah, I mean, just to jump in, I agree with what both Kate and Umar have said. I think also if you look, and of course I'm not going to comment on any particular case at the court, but I think if you zoom out a little bit and again look at the project, the fact that, part of the aim, if international criminal law has an aim, the aim must be not just to be imposing crimes, from outside a society or a culture. If the idea is that these are, in inverted commas, universal norms, then part of the purpose of the litigation is to establish that indeed these are universal norms. And therefore it is important sometimes to have a discussion about whether or not there could be any mistake of law, precisely, if anything, to demonstrate that there was no mistake in that case. That the object, as Kate said at the beginning, it's not convictions at any price. It's just convictions. And again, we need to make sure that the law does apply meaningfully to the places and the people who are subject to it. So, although I absolutely agree with the comments about what the outcome of many of these discussions might be, the fact that we have that discussion, the fact that the Rome Statute makes that a possible discussion to have, actually, I think, helps the project of international criminal law and strengthens it, if anything.
Very good. Thank you so much. And thank you also, Mark, for the clarification on cultural relativism. Again, we have to clarify that what you were saying is about the fact that the selection of the crimes having universal values has been not done by nothing. I mean, there is a specific, let's say, view or perspective that prioritize the interest of certain countries over the interest of others, equally having an interest in stressing the importance of other universal values, that have been not prioritized by the project of international criminal justice. We have still time for other questions from the audience. If anyone would like to write a question, because if there aren't, I would like to give the floor perhaps to Antonio to see if he has comments on what he has been said so far.
Thank you, Paola. And let me thank Kate, Matthew, and Umar for engaging with my book so meaningfully and so deeply and in such a thought-provoking way. In fact, I've been taking notes. I'm not sure what am I gonna do with these notes, if I'm ever gonna amend the book. I don't know. I don't think so. But I want to say a couple of things about the thinking behind the book and how it relates to some of the themes that have been raised by the panelists. And I'm going to start with something that Kate said about the use of the defense during trials, about the risk that there is some sort of stigma for raising the defense as if it is a way of trying to get out of a charge easily, something that should be discounted and dismissed by the judges immediately because it is unrealistic in practice. I think this was the approach of some international criminal tribunals, in fact, when the defense was raised. And it is important to say that there is some sort of bias, perhaps, or there has been in the past, thinking no one can really be ignorant of the law and get away with it, because there is some sort of underlying assumption that not knowing the law is in itself something that deserves punishment, that we are supposed to know what the law is about, and surely for the vast majority of the crimes that are under the jurisdiction of international criminal tribunals, this is true. But it is important to acknowledge that there are crimes for which there are nuances that may lead to ignorance of the criminality of a certain conduct by the person that keeps that conduct. And it's important, in my view, to have the availability of some sort of defense for those individuals, even if then the defense is not successful in practice. Just also to maintain some sort of humility of the project of international criminal justice, humbleness, sorry, if I should say. The idea that not every single provision of the law applicable by international criminal tribunals is perfect. There are provisions that are open to interpretation or can be clarified. And in fact, the very existence of the defense of mistake of law could be a push for lawmakers who write their applicable rules to make sure that they are the clearest possible, for those who disseminate those rules to make sure that they reach the widest possible array of potential perpetrators, and for commentators to try to explain to people the relevance of these rules, the nuances. So there is some sort of educative function that the existence of this defense of mistake of law, in my opinion, maximizes. Because if it wasn't there, we would just stop at saying, ignorance of the law is no excuse. If you know the law, good for you. If you do not know, too bad. But by saying that there are even a tiny, tiny fraction of cases in which ignorance of the law may, in fact, lead to exoneration for criminal responsibility, this puts a little bit of pressure on the lawmakers, on the judges, on the commentators, be them academics or journalists or whoever, to be clear, to try to reduce the space for uncertainty and ignorance, in fact. So this is the first comment that I wanted to make. The second comment that I wanted to make is related to something that Umar said about the divide and who is it that writes these rules and for whom. In fact, in my book, I start from an analysis of domestic legal systems, because I believe most of the concepts that we use in international criminal law derive from domestic criminal law. And in domestic legal systems, those that advocate for introducing a defense of mistake of law in national legal systems usually do it alongside the class divide, saying a defense of mistake of law helps, in fact, the lower classes, those who are less advantaged in getting the means to know what the law is. Even though there is a possible counter-critique that the defense of mistake actually helps those that engage in most technical conduct, tax crimes, environmental crimes, business like company law crimes, and so on and so forth. But anyway, there is this idea that the rich write the rules, and if we have provisions on exoneration of responsibility for unavoidable ignorance, then this preserves the position of the poor. And I think these thinking with the due changes can be transposed at the international level alongside the global north, global south divide, in a sense acknowledging that if these rules that we use, for the most part, use language that derives from, let's be honest, the Western criminal law, be it the North American or the English or the continental European, having rules on exoneration from criminal responsibility based on ignorance leaves a space for acknowledging that there is different language used in other cultures. Therefore, at least we must keep our eyes open to circumstances in which there may be really an impossibility to understand. And of course, I do not want to justify cultural relativism, and I agree with what has been said in response to Kathleen's question, of course. But it's just, once again, that idea that it's always a process of improving, of getting better and better. And so I stop here because I see that there is another question. And I want to leave space for the question, so yeah.
Yes, Antonio, thank you very much for your replies. And we have a technical question by Tofig, if I read correctly, that I'm not the person asking the question. It's a technical one, but it's something that you didn't discuss in the book. She or he wants to know, when it comes to international crimes, war crimes, which enshrine a policy element, we may think of crimes against humanity, but perhaps we may also think of the so-called additional element for genocide, which includes also a pattern of conduct or context for the crime of genocide to be committed at the ICC, before the ICC. Well, when it comes to those crimes having a policy element or plan element, is it necessary that the person accused has knowledge of such an element, first of all? And if so, to what extent does it impact on the defense of mistake of law, the knowledge of all the elements, including the additional contextual elements such as policy and plan? I don't know if perhaps, Antonio, you wanted to address this matter.
I can start. Yes, sure. Thank you, Paola. Well, of course, for the way the defense of mistake of law is conceptualized in the statute of the International Criminal Court, it only comes into play in two instances. Well, I mean, in the classic instance, Article 32, if there is an element of a crime that requires knowledge of a legal provision. When we're talking about policy, we're talking about a fact, right? Typically, a policy to commit widespread or systematic attack against any civilian population, which is part of the contextual element for crimes against humanity. This is a fact, right? So it does not require any legal knowledge, any legal assessment, and so it's not related to the defense of mistake of law per se. It could be related to the defense of mistake of fact, which works in a very similar way to mistake of law. But there it would depend on whether we consider that knowledge of the policy is an element of the crime. And I think we could see differently on that point, because it is not explicitly said. On one side, one may say that according to Article 30, the defendant needs intent and knowledge with respect to all the elements of the crime. The policy is part of the contextual element, which is an element of the crime. So there should be knowledge of the existence of the policy. So that's the first approach. The second approach could say that the policy is not an element of the crime, and therefore it's not necessary that the defendant has knowledge of it, but simply that factually his conduct or her conduct is in furtherance of that policy. In fact, the language in furtherance of a policy leaves the interpretation of both options open. So this is my answer on that. I think I don't know if
I think that topic of since is PhD student in law and doing the thesis on that. I think that is looking for some suggestions. No, we have to wait for the PhD thesis to be written and published to know the answer. That's my suggestion. Anyway, so we have 3 minutes left, and I think that I can use these 3 minutes perhaps for a very last word by the speakers and the panelists about mistake of law. I mean, and the defense of mistake of law in international criminal trials. Kate, so would you hope for a case where mistake of law would be applicable, would be applied? In a case as a defense lawyer, would you like to raise the defense in the future?
No, I wouldn't, but I would be well armed with this book. You do such a good job of going through and explaining, and actually I'm going to really quickly answer the last question that just came up in the chat, of explaining concretely where these doors are open. Okay, and there's not many, but the one in the chat, the disproportionate attacks, the mental element of the legality of a disproportionate attack is an example you cite throughout the book. So buy it, read it. It's really useful to have these sort of concrete discussions around where these doors could potentially be opened in future cases. But I'll stop there.
Nice, fantastic. Thank you for Kate's support for this clarification. And what about Matthew? Matthew, would you think that if in your prosecution activity you would see that perhaps the accused would have some perhaps possible defense of mistake of law? How would you do? I mean, how would you engage with the potentiality of the defense in prosecution cases?
You would start by acknowledging that the burden still rests with you, right? And then go.
You see, there you go. And once again, I always agree with Kate. I would indeed start with that. No, I mean, I think the first thing is, as prosecutors, we absolutely should be engaging with defenses, and we start engaging with defenses before the defense is raised at trial. You know, we're thinking even during the investigation, and this is part of our duty of investigating in a fair and objective way. So we're always thinking about defenses. And again, for us too, therefore, Antonio's book is invaluable, and we're very grateful for that. Because in an ideal world as a prosecutor, of course, you're aiming to build cases where you bring the right cases to court. And if you bring, inverted commas, the right cases to court, yes, of course, there are going to be reasonable discussions about whether or not we've got the facts right and whether we've understood the law properly. But in theory, the object of the exercise is to do justice. So just as much as the defense should be engaged with these considerations, we also should be engaged with these considerations. And of course, on given facts and in given cases, we may take a different view, which is why we are very fortunate to have judges and scholars and colleagues to debate these things with, and sometimes to correct us when we get it wrong. And, you know, we do our best. Sometimes we may not always be right. Please don't quote me as that. As prosecutors, obviously, we prefer to say that we try to be right all the time, but we do get it wrong. And I can see Kate's getting a pen out. So I think I'll stop there. But yeah, absolutely. Defences are everybody's business, not just defence counsel.
Thank you very much, Matthew. And I would like to turn to Umar, who opened his presentation, his speech by saying, well, I didn't study law, I don't have a background in law, just an international relation, just as if it is not important. Of course, it's super important. I mean, the book of by Antonio, which I show again here, has a subtitle, no, it's blurred, so you cannot see it. The title is The Defense of Mistake of Law in International Criminal Law, and then, very nice, a study on ignorance and blame. So, do you think that in a way, international criminal justice project and in general, and international criminal trials can really tell us something about whom to blame or not? It's difficult, huh?
I would say probably that what international courts do is tell us who to blame. But again, that's quite a narrow function of the court and of international justice in general, because it's beyond ascertaining culpability and blame. That's why I believe we ought to think of international law in much broader terms, and also its a connection with other fields, whether it's political science or anthropology and economics and all the other fields. That's why I'm very also happy that I was invited to participate in this. And I'll also say that, the book is an excellent book. It's written also in a very accessible format, because even my non-lawyer brain was able to read and understand it for the most part. Thank you again.
And thank you, everyone. Thank you for participating in this beautiful panel. Thank you, Antonio, for writing this interesting book. And thank you to the audience for your patience and for asking questions and perhaps adding more. I see that now there are perhaps more questions too that I didn't have the time perhaps to answer. We didn't have the time to answer the one by Luigi. There was only one. Sorry, Luigi, we will perhaps keep the question, and you can send us an email, because I know that you know our address, and then we will try to address the question by email.
It's answered in the book. The question is answered in the book. So, Luigi, you can buy it.
You should buy it. Okay, thank you, everyone. Thank you, guys. Bye-bye.
Thank you, Paola. Thank you, everyone. Bye-bye.
Bye.